But Your Honor, let's start at the simplest. Everybody knows the judge's job or the court's job is, if they can set a bond, look at two factors. And I think sometimes we tend to ignore those factors. The risk of flight and danger to the community. We've heard from the Attorney General's office about danger to the community, so I'd like to address that first. The reason it became important is inside of our packet we've included copies of the warrant. Why that becomes important, Your Honor, they start on page 3 of the packet. When you read the packet on the affidavit of arrest warrant, that on or about October 31st, 2015, in the county of Anderson, when Ross Vilardi did, with malice aforethought, cause the death of Terry Michael Scott by causing fatal wound would lead to his death. That's the warrant. Your Honor, I've included relevant case law in the state of South Carolina about what should be included inside of an arrest warrant to justify probable cause. That's not probable cause. That is a bold statement. And that's what we've heard today. The state of South Carolina making bold statements, and the sheriff, the family, and saying what they're saying to community. We believe Ross did this. And since we believe he did this, you need to keep him in jail. Well, that's not the way the criminal justice system works. The criminal justice system is not complicated. What we look at is we look at actual evidence. We don't look at theories. It's troubling, Your Honor. Of course, I'm not from Anderson. I'm not from this area. Neither are you. So I took the time to look at all of the articles, all of the information, everything on this. And it is a repose of statements from the sheriff's office, from law enforcement, from podcasters, from inside mysteries, cold justice, all of these things about what we believe happened. But none of it has a scintilla of evidence. It becomes important when you look at the affidavit and the warrants in this case that there is no probable cause. And when you couple that with the fact that it took 8 years to arrest Ross, but it took 30 days to indict him. So that's really interesting. It took 8 days to arrest, but 30 days to indict. And the arrest is based upon a warrant that has no probable cause, and included in your packet in page 5 and 6, there's numerous amounts of case law that says you got to have probable cause. You can't just scare people into doing something. And that's what we're doing here. We're scaring individuals. And then what we do, what is the easiest way to scare somebody into believing we have a case, is to tie it into the Murdaugh case. And say, boy, we saw the Murdaugh case based upon financial crimes. We've got it. Let's tie him into financial crimes. And there we have it. We have a case. That's not a case. What the state of South Carolina has done after 8 years is come up with a theory. They come up with a theory in which they intend on utilizing in front of a jury, I'm assuming, or in front of Your Honor. This is our theory of what happened on the case. The problem with theories and the problem with themes is they have to be faced with evidence. You can't simply come to the jury and say, they have money, so since they have money, they must have killed him. The state of South Carolina is using a samesies theory with the Alec Murdaugh case. Samesies, it was over money, this is over money, you have to convict. And that's not what they have. I understand they're saying they're going to get more evidence, and it also included inside of their packet, Your Honor, talks about prosecutorial delay. It's taken 8 years to bring this case. The reason it's taken 8 years is because they've looked for evidence and it's not there. I take umbrage with the sheriff's statement to say that they thought they got away with it. When I tell you I've looked at everything, I've heard statements from this sheriff. I've heard statements from Cold Justice. I've heard statements from 2020. I've heard statements from everybody. We have the room filled with media right now. For 8 years, they have been looking into Ross saying, we think you did it. I've heard the sheriff in every campaign stump, everything's possible. We're going to get Ross. We're going to get the Vilardis. So to say they thought they got away with something, first of all, they're saying they didn't do anything. Secondly, for the sheriff to say, oh, they thought they got away with something, I'm sorry, it's disingenuous. Because they've had a microscope shoved up them for so long that they're thinking, we've got it. But they don't. What they do have is they have an amazing attorney general, one I've known for quite some time, who is thorough and diligent and knows what she's doing. And now she has gone in with her team to prosecute a case that they don't have any evidence on. Your Honor, included in your packet, I've talked about the fact that there have been numerous amount of cold cases that have come up in South Carolina here lately. As a matter of fact, I'm representing one down in Charleston that's some 35 years old that a bond was granted on. The difference in a lot of these cases and what the courts are looking at, and it's not just this one, they're looking at all of these cases, and they always talk about one thing. What is the new evidence? What is the new trigger? Has there been a confession? Has there been something new that should trigger a denial of bond? The case that we had down in Berkeley County in front of a judge who simply doesn't set bonds, he made the comment, there is no new evidence in this case. There's no new evidence in this case either. There's a new theory. And so then we get into the risk of flight. there is nothing that the state of South Carolina can point to that will show that Ross is a risk of flight. Why? Because we've been able to watch him for 8 years. For 8 years, himself and his co-defendant have been the primary suspects in this case. They have been who law enforcement has looked at on this case and this case alone. If there was ever a time to run, that was the time. Now, I've been doing this for 25 years. A couple of things that I've always come away with. When someone hires a lawyer before they're arrested, they're not running. And number two, when somebody asks the court permission on a bond to say, can I go somewhere? They're not running. He knows, because we've gone over it. My investigator, other lawyers from my office, we've all sat down, we've gone through the evidence with him. He looks forward to his day in court because based upon the case they have right now, they have a theory. I don't even know if the state can get through an opening statement without burden shifting. Because everything they've said to this court is, why would somebody do this? Why would somebody do this? Why would they have this money? They haven't offered the evidence. They've asked questions that they want Ross to answer. They've gone to Ross and asked him for a statement. They didn't arrest him. They asked him for a statement because there's not a case here. So what the state of South Carolina has done is to placate the fears of a full courtroom, people who are very concerned, very emotional about what has happened. They've come and they said, please deny bond so we can feel better. What happens if you deny bond in this situation on Ross is it makes the sheriff's case stronger. Ha ha! We solved our case in the state of South Carolina and the judge has denied bond. That's not the purpose of bond. The purpose of is he going to show up in court? They have not said one thing he's done during the preceding 8 years when they've looked at what would say he would not show up for court. Nothing. They have used his service to the United States of America against him. That's not what bond's about. That's about his past, that's about his history, that's about things they've done. And what they've done is they said, based upon your past, that's our theory that you must have done it. We don't have any evidence to tie anyone on it. But because you served the United States of America, because you were in the Marines, we believe, not that Judge, I haven't seen a report, I haven't seen anything offered to you about specific hand-to-hand training, but it's a fear tactic. We can come to you and say, well, he was in the Marines, he must know how to use knives, he must have done it. That's not how law, that's not how justice, and that's not how our criminal justice system works. What we'd ask for, Judge, is similar to every other bond that happens in the state of South Carolina in these unique situations. We'd ask for a fair and appropriate bond. One, so he can defend himself. Two, so he can meet and talk to his lawyer, so we can sit down, so we can get ready. And I do find it, and I don't want to put, and I was upset, and I'll tell you, because of the discovery, but the Attorney General's office made it very clear we do have the discovery. But you can imagine a case 8 years old, indicted 30 days later, when there's no probable cause in the warrant whatsoever. So when there's no probable cause in the warrant, that means we can challenge it. I was ready for a preliminary hearing to challenge it. Show me some reason so we can come in front of you and say they have no probable cause. But they indicted it that quick. And I don't think it was the Attorney General's office. I think it happened here. They indicted the case in 30 days. What happens when you indict a case in 30 days? You don't get a preliminary hearing. What happens without having a preliminary hearing? I can't expand on why in the world is this warrant so bad? Why is there no probable cause whatsoever? How did you get a magistrate to sign a warrant without probable cause? I know, because you scared everybody in the community. So everybody has made the assumption that he must have done it, so we don't need evidence. And that's what we're asking you to stop now. Grant him a bond and let us challenge it. Because now he has attorneys who are ready to challenge it, and we're going to challenge it. We're going to look at every single thing. And we're going to find out together. So, Judge, that's all I would ask. I appreciate the court giving me the opportunity. I appreciate the Attorney General's office giving me time to talk. Judge, I'd ask you to take your time, look through our packet. It's got detail. It talks about prosecutorial delay. It talks about bonds that are set in South Carolina. And trust me, this isn't a situation where I just put all the bonds. There's bonds that were denied on all the cases. And there's bonds that were granted. Some were granted at $25,000, some were denied. And it all depends on what new evidence was presented. But we know what's going to happen in this case. Thank you so much. Thank you for your time.